Hi, I'm Ben Stepney. I'm a partner in the employment team at Thomson Standard Passport. I'm joined today by Ashley Matthews, who's an associate in the team. And today we're going to discuss redundancy consultation, an area that often raises questions from our employer clients. So, Ashley, do employers always need to consult with employees when making redundancies?
Thanks, Ben. Yes, so employers should always consult with their employees, no matter how many employees they're making redundant during a redundancy process. So there are two distinct and separate obligations here on employers. You've got collective consultation, which applies to large-scale redundancy processes of 20 or more employees. And then you have individual consultation, and that applies to all redundancy processes, even if just one employee is affected.
So Ashley, let's start with the collective consultation. When does that kick in?
So the duty to inform and consult arises when 20 or more redundancies are proposed within a 90-day period at one establishment. For these cases, there would need to be a notification to the Secretary of State, and there would also need to be consultation of the appropriate representatives of those affected employees, such as trade union representatives or elected representatives. So for these collective redundancies, there are actually prescribed minimum timeframes because you do need to start consultation in good time. So, for example, before your first dismissal, it would be 30 days for redundancies proposed between 20 and 99 redundancies, and then 45 days if you were proposing to do more than that. And there are really significant penalties for getting this wrong or not complying with those rules. So a protective award can be made, which would be 90 days gross pay per affected employee. So it really is important that employers get this right. And it's also worth noting that doing collective consultation does not eliminate the need to do individual consultation.
So Ashley, you mentioned individual consultation. What does that involve?
Yeah, so individual consultation, as I've mentioned, really does apply in every redundancy process. It's more flexible. They don't have kind of prescribed minimum timeframes as you do with collective consultation, but it does have to be fair and it does have to be meaningful. And this could involve fully explaining the proposals at a formative stage of the process to the affected employees, giving them the opportunity to express their views on those proposals and even, suggest any alternatives to making redundancies. You would also want them to have the opportunity to comment on the pool, the selection criteria, the selection criteria as it's been applied to them, and also to kind of discuss alternative suitable employment within the organisation, and really any other concerns that they have. But employers really should not be making any final decisions before they've considered all of the subject matter that comes out during that consultation period.
So some employers think that if they have employees who have less than 2 years service, then they don't need to concern themselves with redundancy consultation. What would you say to that?
So it is true that I think when people think redundancy process, they automatically go, well, unfair dismissal. And it is true that an employee would need to have at least 2 years service in order to bring an ordinary unfair dismissal claim. However, there are other types of claims where a redundancy dismissal may be scrutinised, such as automatic unfair dismissal. For example, if an employee says that the redundancy is actually not the real reason that they were made, that they were dismissed, it was actually because they made protected disclosures, i.e. whistleblowing, or raised health and safety concerns or something of that nature, where they wouldn't need 2 years service. And with discrimination claims, so if the redundancy process was indirectly discriminatory, or again, they say that the real reason for their dismissal was not in fact redundancy, but was actually a discriminatory reason. So for those sorts of claims, you wouldn't need 2 years service. So even if employees do not have 2 years service, it's really important to follow a fair process, because the employment tribunal may still scrutinise the dismissal and could draw adverse inferences from a failure to carry out a fair process.
So Ashley, what are the potential consequences for employers if they don't do redundancy consultation properly?
So as I've already touched upon, there is a risk of employment tribunal claims. There's also the risk of negative impact on employee relations and staff morale, as well as reputational damage. So it's, as I've stressed, it's really important to carry out the consultation, because it can really be costly if you don't.
So how can we help employers thinking about making redundancies?
Well, we can provide end-to-end support for employers. So whether they need assistance with drafting the redundancy communications, or calculating the redundancy payments, or just navigating the process, making sure that they do it lawfully, that they implement objective selection criteria to minimise the risks of doing it wrong. So really whatever support they need from us in order to kind of have a smooth and efficient and lawful redundancy process.
Thanks, Ashley. So plenty to think about then. And if your organisation's unfortunately having to think about making some redundancies for whatever reason, as we've heard, it's important to get the process right from a legal point of view, but also from a monetary and reputational point of view as well. And that's something that the employment team here at Redundancy Consultation can help you with.